On October 13, 2025, Prime Minister Andrew Holness goes to court in a major legal showdown with the Integrity Commission, IC. Why? Because of a 171-page investigation that flagged serious questions about his finances, his statutory declarations, and whether he holds assets disproportionate to lawful income. But this isn't just about financial numbers. It's a battle over transparency, fairness, and how powerful Jamaicans are held accountable. In this video, we'll break it all down. The backstory, the legal arguments, what's at stake, and how this could reshape Jamaica's anti-corruption landscape. Let's dive in. What is the Integrity Commission and the laws involved? The Integrity Commission, IC, is Jamaica's body mandated to investigate public officials' statutory declarations, conflicts of interest, and illicit enrichment. Key laws. Integrity Commission Act, 2017. Governs structure, powers, procedures of the IC. Corruption Prevention Act includes the notion of unexplained wealth, illicit enrichment, under Section Cs, challenged by Holness. The IC periodically publishes investigation reports and rulings. Earlier concerns, filings, and red flags. The IC's own published investigation into Holness's statutory declarations spans 2019 to 2022 and included a special Section 36.3 report and an addendum. In their 2024 investigation report, the IC raised unexplained discrepancies in Holness's 2021 income filing, flagged tax compliance questions, and pointed to transactions of over 470 million Jamaican dollars involving companies linked to Holness associates, many of which declared nil tax returns. The Commission admitted it could not conclude definitively if illicit enrichment occurred, but still withheld certification of his 2021 filings and referred the matter to the Financial Investigations Division, FID, and Tax Administration, Jamaica, TAJ, for further probing. There is also older history. In January 2019, an IC official, Joy Powell, flagged concerns about Holness's declarations from 1998 to 2016, noting that his declared assets increased significantly in the 2009 to 2012 period, with insufficient explanation of funding sources. Powell and another official, David Gray, had requested clarifications, and Holness later supplied a 36-page financial journal covering business activities, investments, assets, and liabilities, going back to 1998. But critics say even that did not fully satisfy concerns about undeclared assets, offshore companies, or the source of funding for real estate purchases. So the IC's 2024 report was not the starting point. It's the latest in a long line of financial scrutiny. Key findings, questions raised by the IC, unexplained discrepancies in Holness's income versus declared expenses, especially 2021. Flagged tax compliance issues. Companies connected to Holness had nil tax returns, but were involved in high-volume transactions. The IC could not certify Holness's 2021 statutory declaration. The report referred certain matters to FID/TAJ for deeper investigation. In its special report, the IC also urged Parliament to consider new laws to regulate commercial, corporate interests of ministers and reduce conflicts of interest. The IC also examined bond transactions, loans, and company activities tied to Holness or his family associates. Holness's response and counter-arguments. Holness strongly rejects the IC's recommendations and conclusions, saying he has broken no law. He states his companies are fully compliant with tax law and filings. He also argues the investigation was unfair, biased, or procedurally flawed, and that some provisions of the IC Act, Corruption Prevention Act, are unconstitutional. What Holness is asking the court to do. On September 30, 2024, Holness and 3 companies: Imperium Investments Holdings, Positive Media Solutions, Positive Jamaica Foundation, filed a judicial review application in the Supreme Court. They asked for about 21 orders, declarations, including quashing the IC's investigation report and special report, or parts thereof, declaring certain clauses in the Corruption Prevention Act and IC Act unconstitutional, especially around illicit enrichment procedures, terminating ongoing investigations into his financial affairs, striking parts of the IC's affidavit as scandalous or vexatious, compelling disclosure of documents used in the IC's inquiry. The Supreme Court granted leave for the judicial review in December 2024. The court clarified, in this review, judges will only examine the fairness of the process, not the substantive correctness of the IC's findings, i.e., they won't decide whether Holness is guilty of illicit enrichment. Court moves and challenges. In August 2025, the court rejected Holness's bid to strike several paragraphs in the IC's affidavit prepared by Craig Beresford, DIC, calling the paragraphs relevant and within his direct knowledge. Holness had also attempted to force the IC to provide redacted documents critical to his defense. That was denied. The court allowed disclosure of certain documents, such as a forensic accountant's report, but paused, the October judicial review until appeals are considered. The judicial review trial is set for October 13, 2025, lasting about 10 days, before a 3-judge panel. Pre-trial reviews and deadlines for document disclosure, inspection, written submissions have been set in the court schedule. What's at stake for Prime Minister Holness? Reputation and credibility. If the court finds procedural unfairness in the IC's handling, it can vindicate him publicly. Legal precedent. If parts of the CP Act or IC Act are struck down, future probes may be weakened. Political risk. This comes after the general election. Negative optics could damage public confidence. What's at stake for the Integrity Commission and governance? Institutional authority. A ruling in favor of Holness could limit IC's scope or hamper future investigations. Anti-corruption credibility. The public scrutiny is intense. IC must show it's fair, rigorous, not politically motivated. Legislative reform push. The IC, in its report, already called for new laws regarding ministers' business interests. Wider implications for Jamaica. Public trust. How Jamaicans perceive accountability at the highest levels. Rule of law versus power. This case tests whether institutions can challenge those in power. Future investigations. If constitutional challenges succeed, many anti-corruption tools may be weakened or revised. Whether Prime Minister Holness gets full access to forensic/internal documents held by IC. Whether the judges strike down parts of CP Act or IC Act, especially the parts dealing with illicit enrichment and burden of proof. How the IC defends its investigative process, whether it proves the procedures were fair, non-biased, and within its mandate. Public reaction during and after the judgments. Media, civil society, politicians. We're watching a high-stakes showdown. Holness versus the Integrity Commission. More than just a legal fight, this case is a referendum on accountability, fairness, and how Jamaica handles public corruption. On October 13th, expect fireworks, and whatever the outcome, the country will feel the ripple. Don't forget to like, subscribe, share, and turn on notifications. You don't want to miss what comes next.